Hello and welcome to the maiden edition of Lawyers Tea. On this podcast, we'll be discussing legal issues, pressing legal issues that people might not have a lawyer to talk about this with. And today, on our very first edition, I'm pleased to make welcome our very first guest on this show. Please introduce yourself.
Hello, Princess. My name is Adefolake Ogundipe, and I'm very happy to be here with you today.
All right, thank you, Folake. Folake is a well-seasoned lawyer, and she'll be assisting us on today's topic. Today's topic is a very pressing topic. It's a sensitive topic, as it were. We'll be discussing wills. So we're going to be delving into the issues surrounding wills, how to make a will, what makes a will a valid will, and other issues that may come out of this expose. Stay tuned. Folake, I want you to tell us about wills. I want to tell us about the word codicil. What does it also imply? And probate. What do these three things mean?
Will is disposition of a testator. A testator is the one making the will now. So is a testator's disposition as to how their legacies or their estate, whether personal or real, is to be disposed with upon their deaths.
Okay.
And will can also entail appointing a trustee for a minor child, can also entail, you appoint an executor to help you carry out the said dispositions that you have in your will.
Contained in the
So,
will.
will basically is just about what should happen to your legacy upon your death. While codicil is similar to will regarding formality. It also should take the necessary formality that a will should take for a will to become valid. But codicil is, like I said, similar to a will, but it's like a supplemental will.
Okay.
Should there be a reason for you to want to amend whether you acquire more property
All
while you are
right.
still alive and
Yes.
you already made a will, but you want to alter or you want to add to, you want to subtract, you want to add beneficiary.
Yes, but you don't want the
You
existing
don't want
will
it
to
yes,
be
it's just like
yes,
a supplement
to be nullified.
to
All right. To
the
the
initial will.
all right.
So that's
Like an
what makes
addendum.
exactly
All
that's
right.
what a codicil is.
Okay.
Why probate is just the process of executing or making the will now become effective upon the death of the testator. That's probate. So these are just like the differences between all these things, but they are all like they work together. If you have a will, definitely you'll get to a probate level upon your death, and that's just the difference between all these things.
Thank you for these clarifications on these somewhat big terms. Now, I want to know: are there specific people that are reserved? Is it only people that have money or that have properties that can make will? What are the people that can make a will? And then I've often heard people say, or more, if they feel like something is about to go down, they'll just whisper into somebody's ear that I beg, carry my Nokia 33 charger, give my friend. So, what is the preferred format for a will? Me saying that to a confidant, saying, "Oh, I want this done. I want." Does that also is that also a will? And like I said, who are the people that are reserved for this
Okay.
special?
For the first part of the question, who can make a will?
Yes.
A will can be made by anybody so far you are of age. The age for making a will is 18 according
10
to the law.
years. Okay.
So once you are 18 years of age, you can make a will. To the will just with the exception of you have to be of sound mind.
Okay.
So persons with unsound minds can't make a will because they can't understand the contents of the said will. So
Okay.
we can't assume that you know what you
What
were
you are
giving to
giving.
a beneficiary and what you were giving to the other. You could have
Okay.
carried the whole thing
Okay.
and mixed it up. So you have to
Yes.
be of sound mind and knowledge and understand the content of whatever
What
it
you are
is
doing.
you are doing at that moment.
Yes.
So basically, the general rule is that everybody can make a will so far you are of age 18.
So it's not just reserved for people that want to
No,
die.
everybody can make a will, and you don't even need to anticipate death before you make a will.
Okay. Okay.
So that answers the first part of the question.
Okay.
And for what makes your will valid upon making a will, you need to make sure the will, because will is something that is statutory. So the will must be in compliance with the statutes. You can't
Okay.
just make a will and say, I just want to write something, just pen down something on a piece of paper. There are um, there are things that need, there are provisions that need to be followed according to the law
Okay.
for your will to become
To be
valid.
valid.
So talking about what makes a will valid, we know that the will must be in writing. That's the first thing. It must be written, because if it's not written, I don't know if anyone can, how anyone can read your mind and know this is really
What
what
you
you want
wanted to
done
do,
upon your
yes.
death. So a will must be written. Then it must also be executed by you. Like you have to sign it,
Sign.
and there is a format to this thing being signed. It's not
Okay.
just appending your signature anyhow.
Okay.
So, for a will to be well executed or properly executed, according to the statutes, it's that it must be signed in the presence of at least two witnesses. So, you need at least two witnesses to be present. They must be present at the same time.
Okay.
So, if A and B is going to witness your will, they must be present with you at the same time.
To bear witness that you signed in your own
Yes,
hand and under with your
they must be
consciousness.
present when you want to append your
Send your
signature. The
signature.
both of them must be
Okay. Not that you
present.
sign and send to them and
No,
say, I don't sign. Oh,
they
let
must
me
be
check out.
present. In fact, there is a provision to that effect that a blind person cannot attest to a will. You can't be a witness to say, "Oh, I was there when he signed," because being present is physically present, and you must have your faculty
Vision.
of sight to be
Sight.
able to say, "I was there."
Thank
Because
you.
should they want to attest? So another thing is, a will can also be made by somebody that can sign. We need to look into that part too and say, I said it must be signed, and
Yes.
it must be signed in the presence of
Two
two witnesses,
witnesses.
at least two witnesses. A will can be made by an illiterate who cannot sign, or a blind person. So where a will is being made by a blind person or an illiterate, the provision of the law is that it must be done. It must be read. The content of the will must be read to them, and they must understand and approve of same. That's for a blind person. It
Okay.
must be read to the blind person, and they must understand and approve before they append
Append
their
their
signature or thumbprint, as the case
thumbprints.
may be.
Okay.
And if it is an illiterate person, the content of the will must be read to them and interpreted to them in their native language, the native language, the
That they
language they understand.
understand.
So, because for a will to just be valid, you just need to know the content of what that will is all about.
Yes.
So,
Yes.
so far somebody is interpreting to you, and you can tell them, okay, you understand, and there will be an illiterate jurat where the interpreter will say that they've read this content of this will to you, and they believe you understand the same, and you approve them to do it, and the interpreter will also sign in that regard. So, like I said, also for signatures, I said the witnesses must be present together.
Yes.
But now the witnesses will now have to attest to that signature, that they attest to it, that they were present when you signed.
Signed.
But when they attest, they don't necessarily need to be together at the same time. Unlike when you are the one signing, that they must be
Signing.
there
Okay.
to attest when you're signing.
Okay.
So that's also basically, those are the things that makes a will valid. It's just about formality, because will is a very formal process, and like we said, it must be in compliance with the statutes.
Yes, and considering that a will comes into existence after a person has died, when the person can no longer say is what I did or what I did not do.
Yes,
So I understand the strictness that has to come
yes,
into play with
yes.
executing a will. On that ground, I want to ask: is it not best to go to a professional to handle it?
I advise people to have a professional write their will, because the professionality cannot be set aside at any time. If you have a professional, they know how this needs to be done, and they will carry it out. It's not about just writing a will.
Mm,
How do you lodge your will in the probate
probate
registry if you are
registry.
not doing it through a professional? So
Yes.
I advise people seek professional help when they want to talk to your lawyers, give them
Yes.
instruction, let them write down the instruction, go through the instructions and see that they are properly carried out. Then you sign, the witnesses also sign,
I
and they
must
lodge
add,
it.
with a professional, it also removes the fear of family members being aware because there's this myth of if my family members know that I've written a will, they might be start cash grabbing,
Yes,
or
yes.
so it takes away, it gives you that privacy when you deal with a professional. It gives
Professional.
you that privacy, and it also takes, the attention off of, the person's supposed assets. In as much as people still contract professionals to assist them with their will, we still find instances of people contesting these wills.
Yeah.
So having a professional is not an all self-serving
Conclusive.
conclusive solution. So my question is this: what are vitiating elements, that's things in a will that will make it contestable?
Okay.
Yes.
The first thing is, like I've been saying, I'm going to repeat it. If it is not in compliance with the statutes,
Okay.
when all those things are not available, the will cannot stand. By the time somebody is contesting it, it's therefore it will be dismissed by the courts.
Okay.
And another thing is customary laws, like the Benin system of Idiogbe, where the eldest son of the family have to inherit the all these things still find its way into
Into proper English
wills.
law.
Yes.
Yes.
So and also there's this personal laws, that's like Islamic law, like the one you
Yes.
choose to submit yourself to.
Two.
So there's this one third, bequeathing your one third of your property to your legal heirs and all those things. When we talking about Islamic law.
Yes.
So those things are still vitiating elements that you need to look into when you are writing a will, okay, or even when you are making your own personal will. Look into, if you have submitted yourself to Islamic law, you need to look into the Islamic law, and if there's this customary law that is still standing and still subsisting in your place,
Yes.
you also need to consider. But the most important thing is when these laws are not in compliance with the statutes. That's like the paramount thing that you need to look into first. And I would also like to add that what can also vitiate a will or a part of a will, because there are instances where the court can strike out a part of a will where the other part of the will will still continue to
Continue to
stand.
stand.
There are instances like that.
Okay.
So also is, if you are given a property, or let's say like an estate that is not yours, you can't give it through your will. You can't, because you are writing a will, now go
Yes.
ahead and give a property that is not yours. It's like
Honestly, if not, we won the whole Nigeria.
exactly.
True.
So it's just
True.
basically the nemo that code non abet, that you cannot give what
What
you
you
don't
don't
have.
have.
It's not yours to give. So if you give it, that part of that will be vitiated. So far somebody is coming to lay claim. And so also family properties.
Okay.
Like
Yes.
family properties, you cannot now say upon your death now you want to give out your the family
Family
property
property.
to
Yes. Like in Igbo land, there's what we call the Obi. Obi cannot go outside of the head of the family. The first son is the
yes.
person that inherits Obi. It doesn't matter your sentiments, or even if you like say, oh, I denounce Igbo
I guess
tradition.
that's the
It
same
will
thing with the Edo
Benin tradition.
yeah,
So
Benin
you can't.
tradition,
But
yes.
so those elements will
So
definitely
they will
vitiate
vitiate
your.
your will.
I
So
understand
that
that.
part of that will become
Null and
void
void.
because it can never stand. But the other part that have nothing to do with this will stand, even despite the fact that a part of the will has been dismissed.
Yes. Who are the people that can contest a will?
Okay.
Because I don't think I can just wake up tomorrow and go and contest anybody's will.
Yes.
That doesn't
Yes.
concern me.
People that can contest a will, these are like dependents of the deceased. Wills law of Lagos State makes this very clear.
Okay.
If you want to contest the will, is either you are the deceased spouse or children. When you come in, you know that the man ordinarily, as a father, you need to make provision for your children, or as a mother, you need to make provision for. If you now in your will skip your children, they can contest and come to court and say, "I'm a dependent with this man or the woman now, and upon his or her death, I was not made
There
provision
was
for
no
in the
provision
will."
for,
So
yes.
I'm contesting this will
On that
because I
ground,
should have,
they cater to.
yes, been a
Okay.
beneficiary
Yes.
under this will. So you can come. Then that's where the court will now determine what a reasonable financial provision will be like. Because at the end of the day, that cannot vitiate the will in its entirety. The only thing the court will grant in that case is them granting you reasonable financial provision.
Reasonable financial provision. So it doesn't entirely negate the entirety of the will.
Exactly.
Okay, okay. But can somebody's creditors, let's say somebody is owing, Lazarus is owing somebody, they have already started announced his will. Can somebody say, look, Lazarus was owing me before he died? In his will, he didn't make provision for
Yes, the creditor can come in and challenge the will.
the
So the
will.
court in that case can, appoint an administrator. Sorry, appoint an administrator that can
Okay,
help.
to settle the
Yes,
debt.
settle the debt.
I don't want to sound like we're trying to bring in a trend to this, but there's currently an issue of a father, or I would say a grandfather, suing a daughter over the will of her father. What is your opinion about this? I don't want to put words in your mouth.
There's a need to challenge. There are provisions for persons that can challenge a will.
Yes.
So if you are challenging a will, the set of persons that should be made provision for is the spouse, like I said,
Yes.
and the children.
Yes.
In the case where he died without a child, but the late spouse is around, is alive rather,
Yes.
then we can consider the relative, like the father, then can come in.
As a
So
next
before they
of
can
kin.
come in now, in this case, it's going to be like whether we don't have children. But in this case, the deceased,
Has surviving children.
exactly. In fact, like we were made to know, like four of them or so. But should the father, maybe before his death, he has made the father a dependent that he has been making provision for. Yes, the father can come in and challenge the will, where in the will
There's no
there's
more
no
provision
provision
for
for him to have his financial standing with the man or under his legacy.
Yes.
Then at that point, we can say the father can come in and challenge the will.
Okay. Thank you so much for Laka. It has been a very wonderful expose. The final question is this. What are the contents of a goodwill?
The signature, because it's very important how the signature is being done, whether you have to just do it according to the statute, like I earlier said.
Yes, so that it's
So
not
the signature,
contestable.
then your legacies or your estates, they can be real, they can be personal, can be your chattel, all those things. Also, you include them. There are times where it needs to be specifically stated. You have like, and there are times where it can be general.
Okay.
There's times where it needs to be demonstrative. Like when it's specific, is like when I'm saying I give Princess, my daughter, I'm giving her my under car. I'll have to state the whether if I have more than one under, I have to be specific of the car I'm giving to you.
Yes.
So it's going to be specific. Or if it's general, then I have to just state generally, I'm just giving you the whole flat in this estate. I'm giving everything to you. Then if it's
Okay.
demonstrative, if I'm saying they should give you $500,000 from my domiciliary account
Who
with,
should
and I
I
state
call?
it. Okay. And I state it. I have to state it. That's very demonstrative. They have to remove it from that particular account and
Okay.
send, because there
Okay.
must be an action to take to that effect.
Okay.
So you have to state all these legacies and how you want them to be done. Then it have to include your beneficiaries. Who are you giving this to? You include them. Oh, and my daughter, my niece, uncle. It needs to include that also. And then also it needs to include the executors, the persons
Okay.
that will execute this
This
thing.
will.
Executors, you can have two, you can have three, you can have four. Basically,
Yeah.
I know people used to have like four, but at the death of one, there can be another person.
Another person.
And there are times where somebody can renounce and say, I don't want to be the executor to this will
Yeah.
for personal
For
reasons.
personal reasons.
In fact, also, Beneficiaries can also renounce whatever it is you are giving them. They don't necessarily have to take it. They can say
Okay.
they don't want it and say, I don't want this gift.
I don't want to be associated with this
Whatever they would,
gift.
yes, and
Okay.
they let it go. So they can also renounce some executors. And if you have minors, you can have trustees.
Okay,
You
for the
can
man.
appoint trustees for your minor because whatever it is you're giving them, you need somebody that can manage it pending the time that they are of
Of
age and they
age.
hand it over to them. It's just basically just include everything you want to happen, just to put your house in order before your death.
Before your death.
That's basically
I
what a
read a
will
will
is.
where the person even outlined how he wanted to be buried, where he
Yes.
wanted to be buried, the
Yes.
account from which the money for him to be buried will come out from. And I think that's very prudent.
It's
It
very,
just
very
it's
prudent.
so that your children don't have to suffer. I
Yes.
think
You can
not
include
just
all
your
those
children,
things.
like the people that you leave behind. As death is already very painful. So having put your house together, it just makes the transition easier for them. It makes the hurt easier. Thank you so much for this. We hope that it has been a very informative session. For you, our viewers, it has been very, very informative. My name remains Ajilore Princess, and this has been Lawyers Tea.